Die Gedanken sind frei.
My thoughts freely flower.
Die Gedanken sind frei. My thoughts give me power.
No scholar can map them.
No hunter can trap them. No person can deny. Die Gedanken sind frei. No person can deny. Die Gedanken sind frei.
I think as I please, and this gives me pleasure.
My conscience decrees, this right I must treasure.
My thoughts will not cater
To do.
After dark, a crowd of teenagers approached the door singing "Onward, Christian Soldiers," and had a long post or a board and began banging it into our front door, which was a very substantial front door. But as I recall, it shook the house. At least my memories might have been exaggerated over time, but it was a rather scary situation. And it reached a point where my mother opened the door to be greeted by a barrage of vegetables and rotten vegetables and other debris. And my mother is not a person who cries much or prone to breaking down, but I think that experience really did lay her flat.
In the late 1940s, Vashti McCollum became a champion of the First Amendment and religious freedom. Concern for the welfare of her children, especially her oldest son Jim, prompted her courageous legal fight against religious indoctrination in the public schools. This documentary is about religious freedom and about defenders of that freedom. It is the story of the McCollum family and two other champions of an unpopular cause, the constitutional right of non-believers to be free from state-sponsored religion.
We have 3 sons. When the oldest one was in the 4th grade, he ran into this program of religious education in the school, public school, on school time. He came home with a note from the teacher that we were supposed to sign, give him permission to participate. We didn't approve of it. We thought that it was religious indoctrination. It was the sort of thing that shouldn't be in public schools. And also we didn't want the religious training in any case. So we kept him out of the class until the peer pressure became so great. Even the public school teacher called and asked that we permit him to participate. Finally, we let him take the course for a few weeks, and we saw that it was pure and simple religious indoctrination. It wasn't a course in general morality and good, wholesome, happy living. And so we took him out of the course. The pressure continued, and when it came to the point that we couldn't resist it, I took it to court.
Being the only child who didn't participate was a bit lonely, and generated a great deal of hostility from the students and to some extent from the teachers. The hardest part was being so isolated from everyone else. It seemed that I was just about the only one in the school that had nothing to do with the course, and consequently had very little contact with anybody except certain teachers who were concerned about my well-being. But generally it was just like being isolated from the community. I suppose if there had been an even split in the class of those participating and those not participating, I would have been left in the classroom to study during times of the religious instruction. But since I was the only one, initially they put me in the teacher's office in the first school I was at. In the second school, they put me in a desk in the hall, which was generally used for detention purposes. Eventually, when my mother complained, they placed me in the music room, which was also a place of detention, and caused certain remarks from the teachers as they came by. But even that was better than sitting in the hall.
It was a program which took time, and it was an inconvenience to the school day and routine. But a more serious problem was that at the very outset, a religious census was conducted to find out what numbers of students were, what the population was religiously speaking, and it segregated from the very outset, just from this preliminary religious census, on through the actual conduct of the classes, segregated people by their religious beliefs. No longer was it any secret whether you were Jewish or Catholic or, in our case, atheist. So I think that in terms of actually invading a essential public area, as education is, and segregating people out by religious beliefs, that it definitely was a very, very un-American intrusion into the system. Unfortunately, the public, I think, started out confused and remained confused as to what my mother's contention really was. The facts of the case were that it was, her contention was that it was an unconstitutional violation of the separation of church and state for sectarian religious groups to come into the school and offer classes, especially on school time. The public, on the other hand, perceived this as an attack upon religion.
We had church services devoted to this discussion of this woman, and of course the children made it pretty hard on our boy that didn't take the course. There was a lot of publicity, and the publicity, and well, it just created a lot of furor in the community. While we had plenty of telephone calls all hours of the day and night, and I think sometimes after it seemed that Sunday evenings were the very worst, when they'd heard a good sermon that morning on the subject, and then they would go home and think it over. They'd call me and they'd give me the works about filing this case and objecting to their children having religion in the schools. And of course I didn't mind their having religion for their children. It was a very good idea if that's what they wanted. It's just that I didn't want religion for my children, and if I did want it, I would have it on my own conditions, and that wasn't in the public school. We received an awful lot of correspondence. I tried to answer it all, but unfortunately many of the anti-letters were not signed. The letters in favor of the action were, well, they far outnumbered the antis, and they were well written, they were well thought out, and they would come at the rate of sometimes 100 a day.
We really were in a sort of a state of siege, and it often found its way as to the kind of ridicule that you would get from day to day with your classmates at school. Often you would hear a rumor that they were going to lay in wait for you on your way home from school, and you got a little creative as to how you picked your route home. There's no question that that kind of thing has an impact. Perhaps just as cutting would be the parents of your playmates, your friends, telling you that they didn't want you to play with their children. Vashti, at the time she filed suit, had been, well, the previous semester, had been an instructor in the University of Illinois Department of Physical Education. At the time she filed suit, the reverberations immediately traveled to Springfield, where a legislator drafted a resolution that it was the sense of the legislature that atheists shouldn't be employed by the University of Illinois. He dropped the resolution when he was assured that Mrs. McCollum would not be rehired. There's no question that my mother bore a resentment to the town forever after, partly because of the general prevailing hostility. The townspeople, the general community feeling was definitely hostile. But I think what actually was even more of a problem to her was that her friends in the university, people who were her colleagues, my father's colleagues, people who had expressed sympathy with my mother's point of view, backed away right after the suit was filed. When it became big news and controversial, people and allies evaporated very, very quickly, and I don't think she ever got over that. As for the rest of us, my brothers and myself, I like to say that the experience can be character building if you survive it. That doesn't mean that everybody survives, and it doesn't mean that everybody builds character on it. But for myself, looking back on it, I see a lot of positive results. But from a child's point of view, this was not a preferred experience. It was not something that you could walk away from very easily. It was constantly with you. You were identified, marked. And I don't think that at any time we were ever totally free when we were with other people. I remember my mother telling me that we had to be especially careful because everybody in town was watching what we did. It was also hard for youngsters, especially myself and my younger brother, to try to deal with this when it caused us hardships, especially not understanding very well the real issues involved. I think to this very day, the presence of, I would say, a residual defensiveness is there and will always be there. I don't think we'll ever totally get away from the experience.
It's a strange thing, but no matter how difficult it seemed to be along the way, I don't believe I ever seriously considered giving up that case. When we had the decision from the circuit court, and it was such a ridiculous decision, you'd have thought they'd never read the Constitution, let alone the laws of Illinois. I just couldn't take that decision, so it was just natural to go to the Illinois Supreme Court. And at this point, we got a new attorney, an attorney who was an authority on constitutional law. Although he lost in the state Supreme Court, we knew we were on pretty good ground. There'd been a case decided by the U.S. Supreme Court the year before that seemed to bode well for us. And so that was the Everson case. So we went on to the United States Supreme Court, and I must say that all during these trials and tribulations, and they were quite a bit for a person that had never expected this sort of thing, we never seriously considered giving it up.
The United States Supreme Court decision in favor of the McCollums declared sectarian religious instruction in the public schools unconstitutional. The strong 8-1 decision was a resounding victory for separation of church and state.
The McCollum case legally was a very significant case. It is the first case decided by the United States Supreme Court that actually held the activity or action of a state municipality to be unconstitutional under the Due Process Clause of the 14th Amendment. Originally, the court in Barron versus Baltimore had held that the First Amendment of the Constitution did not apply to the states because the First Amendment starts out, Congress shall make no law respecting and so forth. So consequently, it was not until after the Civil War that when the Civil War amendments were passed, the 13th, 14th, and 15th, that the sleeper in the 14th Amendment became available. And for us, it became available in our case when the Supreme Court held that the Due Process Clause included the Establishment of Religion Clause. This had been discussed in the Everson case the year before, but the McCollum case was the first case where an action was actually held to be unconstitutional under that particular provision. All the cases that have followed thereafter in the church-state area have been based primarily on the McCollum case and the language of the Everson case. This includes the Bible reading cases, the prayer cases, all of these cases that involve aid to public schools, or aid to parochial schools, and religious activities in the public schools.
Religion in the public schools became a burning issue once again in the late 1950s. Ed Schempp, a champion of the First Amendment, challenged prayers and Bible reading in public schools on behalf of his oldest son, Ellery.
He came home one day telling us that he felt that the present use of religion in the schools as practiced in Abington was patently illegal. And he as much as told us, what are you going to do about it? This, I think, initiated our whole thought about religion in the public schools. We took it up with the Ellery took it up with the ACLU, of which I was a member even before this particular time, the American Civil Liberties Union, and that began a 6-year term which ended in 1963 with a Supreme Court decision that called prayer and Bible reading in the public schools illegal. Meanwhile, Ellery was doing his own protesting in school. He took a copy of the Koran in, and when the other children were reading the Bible, he read the Koran. When they were supposed to stand, he sat down for the Bible reading. This, of course, did not endear him to the school authorities. They did, however, allow him to leave the room while these things went on, but this was hardly any remedy because the PA system blared all over the school in hallways and so forth. He went down to he was allowed to go down to the homeroom teacher or down to the principal's office while these ceremonies, and they called them Bible reading ceremonies. Devotions was another name they called this. There was no question that this was a religious exercise. In fact, that's what the whole case amounted to, is the fact that this was a religious exercise. It wasn't the fact of Bible reading per se or prayer per se. It was a religious exercise which was accomplished with the help of the school authorities, of the public school authorities. In other words, the state has no reason to enforce any religion or particularly religious exercises on the students. The students are a captive audience. And to make one particular religion, really the official state religion of the state-sponsored religion, is very unfair and completely against our Constitution, in which all religions are supposed to be equal. You have your choice of any religion or no religion. And that has to be enforced. And we think our case kept up the proudest of that tradition of separation of church and state.
In 1963, the United States Supreme Court ruled 8-1 in this landmark case that devotional Bible reading and prayers in public schools are illegal.
At the time, in 1963, when this decision came through and the big black headlines say school prayer out of the schools, we got numerous letters. We figured about 500 different letters and postcards. We got innumerable phone calls, some of them at 2 a.m. and things like this. But basically, we didn't suffer undoubtedly. We lived in a community which was very mixed between Jewish, blacks, Catholic church nearby, and while I'm sure they didn't all approve of us, I thought it was in very true American fashion that they put up with us. And incidentally, about 1/3 of the mail we got and so forth was on our side. And we like to think that the intelligent letters were all on our side, because some of the letters that were against us were pretty sad, I'll tell you that. The language they used and the things they hoped would happen to our children, they told us and so forth, were anything but helpful to the laws of the United States.
While the McCollum and Schempp cases have determined prevailing law against religion in the public schools, Torcaso versus Watkins is a unique affirmation of a related constitutional principle, that there shall be no religious test for public office. Few would have predicted that something as simple as becoming a notary would result in another landmark Supreme Court decision. But that is what happened with Roy Torcaso, another champion of the First Amendment.
Well, this began as a result of a request from my employer to become a notary public in Montgomery County, Maryland. He operated a real estate business, and it would be convenient for him to have a notary in the office instead of having to go miles away to get a notary to put his official seal on documents relating to mortgages and loan applications and so forth. My application was submitted, it was approved, and I was instructed to go to the courthouse in Rockville, Maryland, to get my commission. When I arrived there, the clerk of the court proceeded to read the oath of office, which I had never heard before, and it included 2 paragraphs. The first paragraph is a conventional pledge to support the Constitution, to obey the laws of the state, and diligently and faithfully, without partiality or prejudice, to execute the office of notary public. And the second paragraph, which offended me very greatly, states as follows: I, Roy R. Torcaso, do declare that I believe in the existence of God. This I could not accept. I do not believe in any form of the supernatural or any divinity. When I was told I could not be a notary, I went to the law library at the university where I had previously studied and researched cases relating to the office of notary public. I found absolutely nothing there that gave any clue that the state of Maryland had any right to intrude itself into my religious meditations. So I went back home and talked to a lawyer, a neighbor, friend about this, and he agreed to take the case. We filed a suit for a writ of mandamus to compel the clerk of the court to issue the commission. I was defeated in the circuit court. We appealed to the Court of Appeals of the state of Maryland, which was the highest court in the state. I was defeated there, so we appealed to the Supreme Court of the United States, and on the 19th day of June, 1961, the court rendered a unanimous verdict in my favor, unanimous decision, I should say. And I think as a result of this, that freedom of religion is stronger in this nation today than it was prior to this litigation. I would like to read just one paragraph from the decision at the Supreme Court level. This decision, incidentally, was read by Justice Black. He says, "We repeat and again reaffirm that neither a state nor the federal government can constitutionally force a person to profess a belief or disbelief in any religion. Neither can constitutionally pass laws nor impose requirements which aid all religions as against non-believers, and neither can aid those religions based on a belief in the existence of God as against those religions founded on different beliefs." Soon after this case had been decided, I picked up a young man who was a student at the junior college near my home, and in our conversation, I learned that he was in the sociology department where a friend of mine was the professor, and the professor had discussed this case in their class. After some minutes of conversation, I identified myself as the plaintiff in this suit, and this young man was absolutely thrilled. When he got out of the car, he shook my hand most vigorously and said, "Mr. Torcaso, I'm so pleased to meet you. You're one of my minor heroes." I think that is just absolutely delightful.
Today, the right of freedom from religion is increasingly under attack.
I'm rather concerned about the situation today. There is a trend to the right, and I am afraid that if there are additional conservative appointees to the Supreme Court, the work that has, the case law that was established from the McCollum case through the subsequent prayer and Bible reading cases could very easily be undone. And so I think people who are concerned about this issue have should have a great deal of concern. This issue is by no means a closed book, and I'm afraid that most of us, back when this case was decided in the very exciting 8 to 10 years that followed, felt that we had really gained a permanent victory. No victory is permanent in this business, and I think that perhaps there's greater threat to the Bill of Rights and the Establishment of Religion Clause than perhaps any time in this nation's history.
Well, there will be many more cases in the courts, and they will end up in the United States Supreme Court, I'm sure. I just hope that the decision in the McCollum case, which in the past has been the precedent, will prevail. Because if we have prayer in the public schools, whose prayer? And if we have tax credits for the families sending children to parochial schools. That money siphoned off the educational program. I see nothing but great harm to the public schools. Not only that, but I think that more and more the parents will elect to send their children to the more exclusive schools, which will be the religious schools. The children that can't make it will be, quote, dumped in the public school system. And you will no longer have the melting pot that we had that was so valuable in the United States, the service of the public schools. So I see nothing but disaster for the public school system if we have these practices prevailing. And I think that people will see this, will challenge it in the court, and I hope that the McCollum case will prevail.
There can be no freedom of religion without the freedom to dissent. It was a victory for all Americans when Roy Torcaso, Ed Schempp, and Vashti McCollum fought and won court battles ensuring the separation of church and state.
Religion and its implications, this sort of thing, has always been one of the least of my worries. I just have had a very happy life and a very fruitful life, and I get along with people, and they, generally speaking, get along with me. And religion is for the other guy, I guess, or at least organized religion. I'm a humanist, and I've enjoyed that philosophy. I felt satisfied with it, and I just don't feel the need for any organized supernatural religion, and never have.
I think as I please, and this gives me pleasure.
My conscience decrees, this right I must treasure.
My thoughts will not cater
To duke or dictator, no person can deny. Dig-a-dum.